Let me start out with some quick remarks and to welcome everybody in the room, as well as the folks who are watching this live through their computers and laptops and other devices as we are streaming this event nationally as well as internationally. Our capital markets stand as a bedrock to this nation's economy. They fuel growth, innovation, and of course, job creation. They serve businesses of every size and sector and consumers at key points throughout their lives in providing capital as well as credit. But even the healthiest of markets can catch a flu. It is flu season, so I figured I would use that analogy. We thought we cured it back in 1995 with the passage of the PSLRA. But like the flu virus, it evolved. It's multiplying, and it's headed into attack mode. And what I'm talking about, of course, is the proliferation of securities class action litigation that is literally sucking the vitality out of our capital markets. And as you'll hear today, the filing rates for these lawsuits has exploded over the past 24 months. At the same time that the number of public companies in this country are at a historic low. Now, don't just take it from me. Just last week in the Wall Street Journal, they found that the number of publicly registered companies in America has fallen to 50% since the 1990s. Let me say that again. There are half as many public companies today now than there were 20 years ago. Now, look, there's a lot of reasons for that, right? But the fact that nearly 1 in 10 public companies will get hit with a securities class action this year could certainly dissuade private companies from going public. And it's certainly a concern for the SEC. Now, stay with me on this metaphor. Our capital markets are the best in the world. But when you put them under a microscope, you'll see that a contagion is taking root. And if that's left unchecked, it can do some serious damage. Now, thankfully, it's not too late to take action. And today's panelists will guide us through what's happening and what we can do about it. At the outset, let me announce the release this morning of 2 papers by my organization, the U.S. Chamber Institute for Legal Reform. The first paper is titled Containing the Contagion. Can everybody see this? It was written by Mayor Brown partner Andy Pincus, and it chronicles the record number of class action securities filings over the past year, and mostly in federal court, I might note. The paper also offers a number of smart solutions that policymakers, regulators, as well as the courts can take in order to address this spreading contagion that is happening through our federal courts and elsewhere for that matter. The second paper we're releasing today is titled Risk and Reward. It's got this cool little roulette wheel on there, and I think Professor Pritchard is a big fan of it. This was jointly written by distinguished law professors, Professor Adam Pritchard from the University of Michigan, Jessica Erickson from the University of Richmond, and Stephen Choi from NYU Law School. The paper takes a closer look into the incentives that's driving the plaintiff's bar in bringing this litigation, and it questions whether the principal goal of securities class action litigation, which is deterrence, is actually being undermined. So to help us with this discussion today, I have the pleasure to introduce Kevin LaCroix. Kevin has spent 35 years building a remarkable career in directors and officers insurance, and in his spare time, as many of you in this room and on the webcast knows, he writes the D&O Diary, one of the best resources out there for directors and officers and securities litigation issues. Now, if you check out his website, it also has some really cool travel tips for some of the places that he's gone to, including Croatia and through Asia and elsewhere. So it's like a dual-purpose blog that I would highly recommend folks to take a look at. So I can't think of anyone better qualified to guide us through this topic today. So everyone, please give a warm welcome to Kevin LaCroix.
Thank you, Harold, and good morning, everyone. I appreciate Harold's introductory remarks. They lead in very well to some observations I want to make before I turn to my panelists. We're fortunate to have an excellent panel. As Harold alluded to, we have to my right Professor Adam Pritchard of the University of Michigan Law School and a distinguished scholar on securities law and securities litigation issues. And then to his right is Andy Pincus, one of the preeminent Supreme Court litigators of the country, and also a leading commentator on business law issues. And both of them have very interesting reform ideas. We're here today to talk about securities class action litigation. And it's, as Harold's remarks alluded to, it's a topic of perennial interest. And the reason is because securities class action lawsuits are big, they're expensive to defend, and they're expensive to resolve. And so Congress has for years been looking at what can be done to try and tame this beast. But there's a particular reason we're here today, and that's because of very recent trends. As Harold alluded to, we are seeing developments that can only be described as alarming. This simple bar graph just simply shows the number of securities class action lawsuits filed in the United States since 2008. Several quick observations about what the graph shows. First of all, the number of securities class action lawsuits has increased every year since 2012, but more alarmingly, it's increased at dramatically higher rates in 2017 and 2018. And although in this bar graph, 2018 reflects a slight drop between 2017, that's because this bar graph only shows federal court securities class action lawsuits. Were we to add in the state court securities class action lawsuits, in fact, there were more securities lawsuits filed in the United States in 2018 than there ever have been. Now, there are a number of things going on, and Andy's going to talk in a little bit greater detail about what's under the hood, but one thing I want to focus on quickly is that one of the factors in driving the growth in the lawsuits, particularly the last 2 years, is the growth in the number of merger objection lawsuits. These are lawsuits filed after a company has announced it's going to be acquired, and there's an objecting shareholder files a class action lawsuit claiming that the disclosures are insufficient. In 2016, there was a decision in Delaware as a result of which many of these cases that in the past would have been filed in state court are now being filed in federal court, filed as lawsuits alleging liability under the federal securities laws. So that's contributing to this increase. But if you can even subtract out the orange on these bar graphs, you can see the blue portion of the bar is increasing. And as Harold alluded to, the number of companies is down. So as a result of that, what you get is a ratio that shows, this is just, the prior two slides were just numbers. This is a ratio. This is the ratio of the number of lawsuits to the number of public companies. And as Harold said, the number of public companies is down, the number of lawsuits are up. And so what you get is a ratio approaching 1 out of 10, where in 2018, 1 out of 10 of companies listed on the U.S. exchanges was hit with a securities class action lawsuit. Now, if we were to take a further slide and break out the merger objection lawsuits, the numbers would be lower, but they would still show the same proportion. Whereas in the past, the litigation rate was in the range of 2.8 to 3%. It's now approaching 5% even for the traditional non-merger objection lawsuits. So that kind of sets the table for why we're having this conversation this morning, because securities class action lawsuits have always been a problem, but now they're become a much bigger and more prevalent problem. And so to detail a little bit more what's behind these numbers and also to suggest some measures that might be taken to address these concerns, I'm going to now turn the table over to Andy.
Thanks, Kevin, and great to be here. Thanks to ILR for putting this event together. Just to pick up on a few of the trends that Kevin mentioned, I've been watching securities class actions, frighteningly enough, for the past 25 years since Congress was debating the Private Securities Litigation Reform Act back in the mid-1990s. And I think the parallels, as Harold alluded to, are striking in terms of where we are now and where we were then. Then Congress was concerned about a sudden jump in securities class actions. Then it was about class actions focused on tech companies that were focused to a large extent on earnings predictions and missed earnings predictions. Here we've got these M&A cases that have migrated from state court to cause a similar problem, and a second trend that I want to mention as well. Back then, there was concern that the lawsuits seemed to be driven more by lawyers rather than real clients who had a real problem. Lots of lawyers who were repeat players, lots of lawsuits filed by the same plaintiffs, 20, 30, 40 cases filed by the same plaintiff. The PSLRA tried to deal with that, but as Harold said, things have morphed, and to some extent we're back in that same world where we have professional plaintiffs again bringing lawsuits. Part of Congress's concern then was not just professional plaintiffs, but lawyer control. Congress said we're going to put institutional investors in the driver's seat in litigation in order to try and get a client's voice there, rather than lawyers who obviously have a self-interested interest in the fees at the end of the line. And so Congress created a lead plaintiff structure that put clients in the driver's seat, and it was designed to encourage institutional investors to participate in the litigation. That worked for a time, but studies show that the percentage of lawsuits in which institutional investors are a lead plaintiff has been dropping. The percentage in which individuals are once again, and in many cases these individuals who are repeat players, repeat plaintiffs, are rising. And some evidence is that institutional investors just don't see a lot of these lawsuits as worth their time, and so the plaintiffs' lawyers who sort of make a living by filing lawsuits have gone elsewhere to find plaintiffs to bring the lawsuit, but that means we again have lawyer-driven litigation. And the results, an analysis showed that the results actually, when it's an individual plaintiff versus an institutional plaintiff, are generally worse for the class and generally better for the lawyers. Perhaps not surprising that that's the result. But again, the precise problem that Congress wanted to address, tried to address in the 1990s, its solution worked for a while, and now we're back where we are. So I think the parallels are quite striking in terms of where we are and the need for some kind of intervention. So just to talk for another minute about the kinds of litigation, as Kevin said, part of the issue here is the migration of the merger and acquisition lawsuits from state court to federal court. And that migration didn't happen by accident. It was the result of, in large part, of a decision by the Delaware Court of Chancery, which looked at these cases, many of which were filed in Delaware, and said, gee, we seem to be getting a lot of cases where we are asked to approve a settlement that has some additional disclosures relating to the deal that seem pretty meaningless to us, and attorney's fees for the plaintiff's lawyer, in addition to a resolution of the class claim so that the company then faces no litigation. We're not going to approve these settlements anymore. We're going to look hard at what kind of relief is provided, and if there's no serious relief provided, we are not going to approve the settlements, and we're not going to award attorney's fees. So the result was dramatic. Just like that, as the bar graph showed, the cases migrated away from state court and into federal court. And the problem with that is they're in a large number of federal courts. Part of the rationale of the Delaware Chancery Court is business litigation is focused in a place where Delaware law can be applied in a consistent way. Got a lot of federal courts hearing these cases. They don't see many. Maybe they don't see the problem. And also, the plaintiffs' lawyers changed their strategy, and rather than seeking a class settlement, which has to be approved by the court, they negotiate out-of-court settlements where the company agrees to some disclosures, most of which have been found to be non-material in an analysis of these kinds of settlements. And there's an out-of-court payment of a so-called mootness fee, which goes to the lawyers. So real questions about how federal courts can get their arms around these cases. But I think if you're someone who looks at litigation trends, it's hard not to say that this trend has every possible indicia of abuse. I mean, the Delaware courts cracked down. What happened? The case migrated to federal court where that crackdown didn't work. And there's a workaround so that there's an attempt to eliminate all court supervision of those cases. So troubling, A, and I think B, just to give you a sense of the numbers, studies have shown that upwards of 90% of the deals in the United States involving a public company valued at over $100 million are met with at least one lawsuit. So unless you think that 90% of the companies in America are engaging in fraud on every deal they do, there's a real problem here. Quickly, the second trend, and Kevin has written a lot about this, is what has been called event-driven litigation. It used to be, in the olden days, that most securities class actions were based on alleged financial shenanigans, problems in the audited financial statements, as I said, problems in predictions, things relating to the economics of the company. now, many, many cases are based on adverse events that happen in the company's operations. I mean, just this year, a plane crash, the plane manufacturer was sued in a securities class action. Forest fires, the electric utility was sued in a securities class action. A hack of a company's customer information, the company was sued in a securities class action. A dam collapses, the company that built the dam is sued in a securities class action. The claims in all these cases are, you didn't warn us sufficiently of this material risk that these bad things will happen. Now, if you step back, is there really a material risk that those bad things are going to happen back before they happened? But that's the theory of the case. The claims are, many people, including Professor John Coffey at Columbia, have expressed great skepticism about the legitimacy of these claims. But you can't have any skepticism about their power as a weapon, because the company doesn't want continuing litigation about this adverse event in its business. It wants that litigation to go away. Much of that litigation will be tort claims and others relating to the underlying event. Companies typically want to resolve them and get on, but now they have another lawsuit piled on top of that, a securities class action. That's another source of this growth that I think has to be looked at and discussed.
You know, thinking about the context of those event-driven lawsuits in the context of our financial markets and then the U.S. financial market in the global economy, picking the airline manufacturer as one example. I mean, obviously, Boeing competes with Airbus, but Airbus doesn't have to put up with that business risk of this added cost of the litigation. Both face the equal risk that one of their planes might be involved in a terrible tragedy. And there are very real consequences if there is a tragedy, but added to all of the consequences the company faces, the idea that they have to face this litigation. It's an added business cost that companies that are listed on the U.S. exchanges face that other companies in other economies do not.
I think that's right, and I think it's important for those folks who are either here or tuning in who are not familiar with securities class actions to say, we're talking about 400, 420, 440 lawsuits. It may not sound like a lot, but these lawsuits, as a friend of mine likes to say, are sort of the battleships or the aircraft carriers of the litigation system. They typically seek literally billions of dollars in damages. The cost to litigate them, as Kevin knows better than I, are astronomical. And so, although the numbers are small, each case is a gigantic, gigantic additional burden, as you say, for the company that's involved. And just to pick up on your point, and I think it connects to a point Harold made, the diminution in the number of public companies is not typically a problem for institutional investors and wealthy people, because they have opportunities off the market to make investments in non-public companies that ordinary people typically don't have. And so who's hurt by the reduction in investment opportunities in public companies? That's real people who are looking, maybe they don't want to put all of their money in a mutual fund. They'd like to make some investment decisions themselves, and those options have been cut in half.
So before we move to Adam, do you have any thoughts on ideas? What can we do? What can be done? And I know Adam has many thoughts as well, but what are your thoughts?
Yeah, I think just quickly, and I'm sure we'll talk about them more, but I think different players in the system, in the federal system, have a role to play. I think, first of all, the SEC, which really is, whose job is to safeguard the capital markets and to protect investors, has an obligation to look at these two new trends, the M&A cases in federal court and the event-driven litigation, and make an assessment of what's happening and whether this is good for the system, whether it's good for investors, and if not, to suggest reforms, but especially with the M&A litigation, where the problem really is this diversification among federal judges who may not know what the scope of the problem is, to then use its amicus brief filing power to educate judges about these two kinds of cases and why perhaps you should be more skeptical and more aggressive about trying to rein them in, because although you're seeing one case, there are systemic effects that the courts have to be concerned about. So I think that's one important chunk of things that should be done. And the other, although it's a longer-term effort, it is for Congress to take a look at this as it did in the 1990s, because the exact same problems, as I said, were here. And, I think it's important. People may not remember in the current polarized Washington, but the PSLRA was a consensus bill that ultimately passed with 2/3 of the House and 2/3 of the Senate over President Clinton's veto because there was such widespread support for the problem. So there are a couple of things just to tick them off. You mentioned the trend of the new state court filings, which are a result of the Supreme Court's decision in a case called Cyan that held that claims under the Securities Act of 1933 can be brought in state court and can't be removed to federal court. So in contrast to almost every other kind of securities action, which Congress in both 1995 and then again in another statute in 1998 said, we want these claims centralized in federal court, the Supreme Court said this statute doesn't quite do the job. And so this whole category of claims can be brought now in state court, and the data tells us that that's happening. As you said, I think the number is 33 of those claims were filed last year in state court, a dramatic increase, some of them without a parallel federal court claim, some of them, the most of them with, however, or half of them with, so you have companies facing dual litigation, two tracks at once. And I think it's important to note that the 33 Act claims are claims that relate to initial public offerings. So they're actually claims directly targeted at companies that are going public. And so this split and the additional burden that it causes is really a direct burden on companies entering the public marketplace. So that's something that Congress could take a look at and quickly fix. If the SEC's amicus effort and what the SEC says about M&A cases doesn't work, there certainly are things Congress could do to centralize the M&A cases in federal court, maybe have them filed only in the state of incorporation of the target company, so that would then centralize them in a few states where the judges might become more familiar and able to deal with them as Delaware did. And then I think there are some steps to eliminate the new kinds of lawyer control that I mentioned, taking steps similar to what Congress did in 1995 to put plaintiffs, real people, back in the driver's seat. And then in the longer term, I think there's been a lot of talk and a lot of economic analysis about whether the whole class action system, especially the lawsuits that relate to sales in the public, aftermarket sales, not IPOs, whether it makes sense when the company doesn't profit hardly at all from any of those sales to have the company pay billions and billions of dollars in an exercise that really is draining money from the current shareholders to pay a class that includes a lot of the current shareholders and maybe some former shareholders with a huge amount taken out for transaction costs and legal fees. And many observers, some research by ILR, but also observers like Professor Coffey have said a damages cap is really a sensible thing here to make this a more economically rational endeavor.
And many of those topics are filled out at greater length in your papers.
Yes, talk more about it.
So, Adam, you've done a lot of research on securities class action litigation and come up with some very interesting observations about the dynamics and the sort of the incentive structure. And based on that research, I know you've come up with a number of recommendations. So what are your thoughts on this topic?
So this is my chance to talk about what I did on my summer vacation. For those of you who think that their professors have it pretty sweet in the summer, no, that is not true. This is a paper with Steve Choi and Jessica Erickson, and what we did this summer was collected data on securities fraud class actions, and we collected data on the population, all of the securities fraud class actions in federal court from 2005 to 2016. So our study period predates a little bit the trend in the last couple of years with the mergers and acquisitions lawsuits. Those really started to come up in 2017 and 2018. The reason that we're looking at a little bit earlier period is because our particular concern is the role of attorneys in these lawsuits and the business of securities fraud class actions. So a little over 1,500 lawsuits in that period of time. Institutional investors show up as the lead plaintiff in 55% of those cases. So the business of acquiring institutions as the lead plaintiff for class action lawyers is an important one. The typical lead plaintiff group has a little under 2 lead plaintiffs. There are 3 lead plaintiff applicants in the average case seeking to be appointed as lead plaintiff by the court. So a little over 1.3 firms per lawsuit are appointed as the counsel for the class, and about half of the cases are litigated by big law firms, which we define as firms with over 100 lawyers. So these are not mom and pop lawyer shops. They are big law firms. They're doing things on a big scale. So about half of these cases get dismissed. A little under a quarter of them get to the point where a class certification motion is filed, and that's typically the point where a settlement is going to happen. Very few of these cases get to the point of a summary judgment motion where the evidence would actually be assessed, right? And conspicuously lacking here, I'm not giving you the statistics on trials because those don't happen. All right, that is not a thing. These cases don't get adjudicated. We don't get a determination of whether or not fraud occurred. So we collected the settlement information for all of these cases, and the specific focus, main focus, is on the attorney's fees, requests, and rewards, what they were awarded by the court. So I've got some charts that show you what we found, and I'll hopefully be able to explain why we think the data we've collected suggests that there is room for reform that would make investors better off. So this is breaking down the average settlement by decile, so splitting all the settlements in groups of into 10 groups, and you see there's an enormous skew in this chart. In the biggest cases, the largest settlements, top 10%, the average settlement is close to $300 million, right? But the vast range of settlements are below $15 million, right? And this is the area where Andy is concerned that a lot of these settlements are in the range of defense costs, right? That it is, whether or not you think you committed fraud, it's cheaper to make this go away by writing a check than it is to hire Mayor Brown to defend you. So the incentives for bringing these, so this is now breaking down the deciles by the type of allegations in the cases. So we looked at the complaints, the last complaint in the cases, and we collected whether there was an allegation of a restatement. So the auditors told the company that they had to restate their financial statements, an investigation by the SEC, an investigation by another government agency, might be DOJ, might be a state attorney general, and did somebody get fired, right? So if the CEO or the CFO got fired, that is an indicia of a problem. All of these things are publicly available to plaintiffs' lawyers when they are drafting a complaint. They don't have to ferret around and do investigation. They're all publicly announced, and it's simply a matter of assembling these allegations into a complaint. And what stands out here is the largest settlements have the highest score. This is possible 4 here, but the range is not dramatically skewed, right? So slightly more of these allegations are found in the larger settlements, but not dramatically. The only bar here that stands out is the cases that are dismissed. So there are a good number of cases that have only have less than 1 on average of these allegations, and there's a clear correlation with dismissal. So you see the pleading standard of the PSLRA has some real teeth in weeding out some of these cases, but there are limits on what that can do. So what we found in the data is that plaintiffs' lawyers have a pretty good sense of what case is going to produce a payday. So here is our friend Elon Musk, who is much in the news today. The SEC yesterday said he was in contempt of court. At a minimum, he sometimes lacks judgment in the use of social media. I think it is fair to say. So when he tweeted out his plan to take Tesla private, that drew a dozen law firms with lead plaintiffs that they rounded up to file lawsuits against Tesla and Elon Musk for what looks like a pretty easy case that there is going to be a settlement. And so that feeding frenzy in cases against big companies where the likelihood of recovery is very high, it shows up in our data, right? So this is the number of lead plaintiff motions filed on this chart, and the bar, so it says, shows you how many on average of those cases got dismissed. And you see when you had 10 or more law firms showing up to file a case, that a very small percentage of those cases got dismissed. If only one law firm showed up, 60% of the cases got dismissed. What this tells me is that the publicly available evidence that the plaintiffs' lawyers are relying on to file these cases gives them a pretty strong indication of their likelihood of recovery. So why are these cases being filed where there is little competition, right? What is driving the cases where there's only one law firm showing up? So this is breaking down the fraction dismissed by the size of the company. This is a very rough proxy for what the likely damages are in a case. And you can see that for the smallest companies, the dismissal rate is quite low. So plaintiffs' lawyers are not taking flyers on risky cases against small company. Where are they taking the risky cases? When you have large market cap companies where the payday at the end justifies taking on the risk. So the rate of dismissal very high for the cases against the largest companies. And you can see why the lawyers are willing to do that, right? Because the settlement size in the smallest market cap companies, the average is under $10 million if you looked at the bottom four deciles together. But the settlement size in the top three deciles is well over $100 million. So we're going to have a good chance of getting our case dismissed against this large company, but if we get past the motion to dismiss, there's going to be a really big payday. So the question that my co-authors and I wanted to see was, so some of these cases are producing the really big settlements, and the rewards to the plaintiffs' lawyers in those cases, what drives those? And this is breaking down how much litigation effort is put into these cases. And you see the cases against small companies are getting a lot less work put into them by the plaintiffs' lawyers. The lion's share of the work is going into the cases against the big companies. And this lets you see why the cases against the big companies draw the lion's share of the work. So here we have the number of hours in thousands that are being invested in these cases. Those jackpot cases, the close to $300 million settlements, they're getting 62,000 hours of litigation time. So putting in a lot of warm bodies, churning up the hours. But what really is striking from the data we collected is the hourly rate that is being paid in those mega settlement cases. They're putting in the largest number of hours by orders of magnitude, right? But the average billing rate in those cases is close to $1,000 an hour, all right? And that's less than Andy gets, I'm guessing, but it's more than I get. And that's including a lot of time spent on contract attorneys, on junior associates who typically would not be able to bill an actual client anywhere near that range.
Yeah, I would say most corporate clients, if they knew that they were going to pay a blended rate of $1,000 for their matter, would be firing the law firm and hiring somebody else.
Any competent general counsel would not let that go past. So, how is it that so many hours are being put into the largest cases? So here we've taken the number of docket entries, which is an indicator of how much litigation activity is going on, and we've looked at the number of hours per docket entry, and in the 10th decile, the biggest settlements, the number of hours per docket entry is twice what it is in the 9th decile. And you see in the smallest cases, the number of hours per docket entry is only a little under 11 hours per docket entry. So the work is being attached to the largest cases, and the question is there that much more, many more things to be done in these cases? The basic pattern is set by the law. There are a number of issues that have to be established. It doesn't really vary with the size of the case. So we see that the plaintiff's lawyers are making most of their money off of that top decile of cases. So this suggests the lottery element of securities fraud class actions, that people in plaintiffs' law firms want to get that big case because that's where they can get the payday that is going to produce the Learjet for the partners, right? So the reforms that we are suggesting in connection with what we perceive to be a problem with the lottery ticket element, currently judges do not impose a lot of scrutiny on the hours that are being claimed by the lead plaintiff's lawyers in these cases. 95% of the cases that we looked at over this period of time, the fee request that was put in by the lawyers was approved without any change by the court, right? And in reading the fee award decisions, very rarely is there any analysis of what the marginal contribution of the lawyers were in producing the settlement in the case. The earlier slides that I showed you, the chart showing the size of the settlement relative to the market cap of the company, plaintiffs' lawyers are being rewarded for suing big companies, right? What they have achieved is they got the client with the largest losses, and they're getting paid very handsomely by the courts at the expense of the class and at the expense of shareholders for securing that lottery ticket, right? So one thing that judges could do is look to see what did the lawyers do beyond the publicly available indicia of fraud to produce a good settlement for the class. So if all you're doing is packaging the restatement and the work by the SEC and investigating the case against a big company, you shouldn't be receiving $1,000 an hour for doing that work that any junior associate could do based on public filings. The other thing that courts should look at, if there is a feeding frenzy of law firms at the outset of the litigation to try and represent the class, as there is in the Tesla case, that is a very strong marker that this is a low-risk case, and the plaintiff's lawyers understand that, and there should not be any significant multiplier awarded to the lawyers for taking on risk, because these are essentially close to zero-risk cases when you see 10 law firms showing up competing to be lead plaintiff. That's what judges can do. We don't have a lot of confidence that judges are going to be proactive in policing these things. Congress and the PSLRA imposed a limit of reasonableness on fees and told courts that they were supposed to scrutinize these fees. But this is not interesting work if you are a federal judge, I think. You're knee-deep in billing records, and most judges are not interested. So Congress has a role to play, too, And particularly, we need statutory changes if we're going to discourage the lottery ticket business model of class action lawyers. So we believe there should be a presumptive fee limit in these mega settlement cases of between 10 and 15%. What is required to encourage law firms to come forward? There's every reason to think that 10% of $100 million would be enough to encourage law firms to bring these cases. Some of the abuses that have been identified that we think Congress should act to prohibit naked fee sharing. So we have lawyers who are in the business of producing clients that securities class action firms can use to get lead plaintiff status. We think that paying fees to these search lawyers should be prohibited by Congress. And we also saw in collecting the data that lawyers were doing work on cases who were not approved as lead counsel by the court at the beginning of the case, and were nonetheless being approved for work on the case. Are we receiving fees for work on the case despite not having been approved? So we think that the court should approve any law firm that is going to be collecting a fee at the end of the case prior to doing any work on the case. And that would be a way of discouraging make work to justify referral fees for law firms that are in the business of producing plaintiffs. The other reforms that we are suggesting, the principal one is putting a limit on the maximum damages in these cases because it is not necessary to have a potential damage bill in the $5 or $10 billion range to get attorneys to take these cases, right? The point of awarding damages is to encourage these private attorney generals to bring these cases. We should set the damage award and the potential fees at a level that is sufficient to encourage lawyers to take the cases. Anything above that is a windfall to the lawyers, and it's a windfall that's being paid by the shareholders of public companies who probably have better things to do with their money. So we think that the damages should be limited in an effort to discourage the lottery ticket mentality, with exceptions for the public offering cases where the company has actually been selling securities. That's maybe 20% of the cases. 80% of the cases are open market fraud cases where investors are buying and selling the securities amongst themselves, where the social losses from the fraud are pretty trivial, because for every shareholder who paid too much for their securities as a result of the fraud, there is a shareholder on the other side who received too much when they sold their securities. So the social costs are much lower than the damages formula typically used in these open market fraud cases, and we think a damages cap based on market capitalization is a good way of still encouraging deterrence without putting shareholders on the hook for windfall awards.
That was great, Adam. That was really fascinating. We're just about out of time, but I think we have a minute or two for questions from the audience. So are there questions?
So Kevin, while we're waiting for questions, can I just make one comment, which I think, just sort of stepping back from this really fascinating study, I think what it tells you is the lawyers really are in control, because what Adam's analysis and his colleagues' incentives tell you is that the cases are focused in areas where lawyers have the plaintiff's bar has the best incentives to get the most money. And so I think that tells you that in thinking about how the system works, it's all about what the incentives are for the lawyers. That's sort of the critical driver. Maybe there's a way to put more institutional investors in control, but what I take away on the big picture is you really have to focus on those incentives and drive those lawyers to focus on the cases where there's the biggest likelihood of fraud if you're going to change the system.
Yeah. So any questions before we wrap up? No? Harold, I think that's it for us.
Well, as long as there are no questions. Just again, to sort of pick up on your last point, I think about the social costs and the compensation. Typically, any kind of private litigation is justified by sort of a compensation rationale and a deterrence rationale. And I think what you're saying is the compensation rationale doesn't make a heck of a lot of sense when you look at these open market cases, because you've got people, you're taking money away from people who didn't do the fraud, the existing shareholders, and giving it to another group of shareholders with this big transaction costs. But also, although there may be shareholders who were on the losing side of the transaction, as you described it in Company A, given the prevalence of institutional investors, they could have benefited from the alleged fraud on Company B, and so there's some washing out effect.
So it does wash out. The way I explain it to my students is, if we didn't provide compensation to the investors in these cases, what would they do? Would they leave the stock market, or would they diversify their portfolio so that they would have a chance of being on the winning end as often as they are on the losing end? And my argument is that diversification is cheap and easy and good for you, and that's how investors would respond if the compensation were reduced. And of course, the compensation paid in securities fraud class actions is generally a trivial percentage of any market losses.
Thank you, gentlemen. Please thank our panelists for this discussion.